It's not often that the Supreme Court hears landmark cases that define the free speech rights of Americans. In fact, you can argue that such an event happens maybe once every decade. Oftentimes, you have to go back many decades to understand the scope of free speech rights by going back, for example, to the Brandenburg case that the United States decided in the United States Supreme Court decided in the late 1960s that still defines the outer contours of political speech and what it protects in the United States. Or the Claiborne ruling, which occurred in the early 1980s by a unanimous Supreme Court that sets limits on how people can be held responsible for the consequences of their speech. It's not often that the U.S. Supreme Court issues a landmark ruling that defines free speech. And I would argue that the oral argument that the Supreme Court held today is the single most important free speech case, not only in decades, but the single most important free speech case in the digital era, where it's not newspapers that are our primary means of hearing news, as happened, for example, when the New York Times ruled that the Nixon administration could not issue an order of prior restraint against the New York Times to prevent publication of the Pentagon Papers, another landmark ruling that happened in the early 1970s. It has nothing to do with television. This is about the role that the United States government will be permitted to play in attempting to suppress online political expression, political speech of American citizens on the primary means by which we now trade ideas and hear one another's opinions and news from various outlets, which is the internet. And we have reported extensively on all the different ways that the U.S. government, and not just the U.S. government, but the EU government and the UK government and the Canadian government and the Brazilian government and governments around the world now understand that the power of the internet is so great, is such a threat to power centers and to establishment orthodoxies, precisely because when it's free, it is impossible to centralize ideas and power, and therefore it is impossible to control the flow of information. And that is why Western governments, including the United States, have made it a priority to create theories that allow it to justify why they have to control the internet, why they have to suppress free speech, why they have to censor. And one of the things they do is they have to create theories that justify and convince Americans that they ought to not just tolerate this censorship, but crave it. And one of the arguments the United States government has long made is that we have to keep you safe from hate speech. But a lot of Americans now understand that hate speech is such a malleable concept that it's dangerous to simply endorse the idea that the government can censor hate speech, because that's often in the eye of the beholder. But after 2016, when free speech on the internet led to things like the British people opting to leave the EU through Brexit, and most importantly, the American people defying what they were told to do and voting for Donald Trump instead of Hillary Clinton, it became the number one priority of American financial, political, and media elites to create theories, new theories to persuade Americans to support censorship. And the primary argument they created was that there was this new kind of danger in the internet era called disinformation. Disinformation, we were told, comes often from foreign powers. It helped interfere in the 2016 election and foster the result that American liberals to this day regard as an apocalypse. Disinformation, they say, is what convinced Americans not to take the vaccines they were told to take and therefore died in large numbers. That disinformation is this grave threat, and therefore we need the government to protect us from it. And this has become the leading orthodoxy in liberal thought, including in most parts of the corporate media, which of course have a liberal ideology. These are people who live in liberal cities, who circulate in liberal cultural precincts. And so the idea that the US government has to be able to control the flow of information to protect us from disinformation and the dangers that it creates, including by, even especially by, dictating and influencing and coercing what is and is not permitted to be said online, has become one of the central ideological beliefs of American liberalism, broadly speaking. Meaning everything from the left wing of the Democratic Party to the establishment liberals like Hillary Clinton and Chuck Schumer and Joe Biden and the people who surround him, to the centrist and even parts of the establishment of the Republican Party who have all united in the belief that disinformation is something that can be defined. Typically, it means dissent from establishment orthodoxies. It is dangerous to be permitted, and therefore we have to censor in order to stop it. And that is what is at the heart of what the Supreme Court had to decide today. And it was obvious that many of the justices on the Supreme Court, not only the liberal justices, but several of the conservative justices as well, believe that it is most definitely an appropriate role for the United States government to play to, at the very least, pick up the phone and call big tech companies in private and convey to them which views they think should be suppressed and which people they think should be silenced. And while most everybody is willing to agree, except for Justice Brown Jackson, that what the U.S. government cannot do is accompany those requests with explicit threats, meaning unless you censor the way we tell you to, we will destroy your company. Pretty much everyone except for Justice Brown Jackson seems to agree that that is not permissive. What they seem to be believing is that even when the U.S. government is throwing its weight around, when they're having the FBI call the big tech platforms at the same time that they're threatening to punish them in all sorts of ways by removing protections under the law that they need, or by attacking them in regulatory and legal ways, that there's somehow nothing sufficiently coercive about that behavior that makes it unconstitutional, even though the 4 federal judges underneath the Supreme Court who have all looked at this question all agreed not only that the Biden administration was violating the Constitution, but was doing so in a flagrant and glaring way. Now, there's other questions that the Supreme Court has to decide that are more technical in nature, which we'll get to, including whether or not these plaintiffs who brought this lawsuit even have the right to sue the U.S. government at all, and whether they could actually prove that the reasons they were censored was because of the U.S. government. But on the merits itself, there were a lot of very disturbing comments that were made, not only by the liberal justices, but by several of the conservative justices as well, including Brett Kavanaugh and Amy Coney Barrett and even John Roberts, that makes me, if I had to bet, believe that it is more likely than not that the U.S. Supreme Court in this case will find a way to reverse the appellate court in the district court and throw this case out and not give the American people what we need more than anything, which is protection from official state censorship through the power of big tech in the digital era. Now, I want to begin by playing for you one of the more encouraging exchanges, which was an exchange that took place between Justice Alito and the lead lawyer for the government, who's the Deputy Solicitor General. And this was Justice Alito explaining to the government what his reaction was when he looked at this broad record of how often and continuously and aggressively the government was telling big tech what they wanted censored.
Exchange between the White House and other federal officials and Facebook in particular, but also some of the other platforms. And I see that the White House and federal officials are repeatedly saying that Facebook and the federal government should be partners. We're on the same team. Officials are demanding answers. I want an answer. I want it right away. When they're unhappy, they curse them out. There are regular meetings. There is constant pestering of Facebook and some of the other platforms, and they want to have regular meetings. And they suggest, they suggest rules that should be applied, and why don't you tell us everything that you're going to do so we can help you and we can look it over. And I thought, wow, I cannot imagine federal officials taking that approach to the print media, our representatives over there. If you did that to them, what do you think the reaction would be? And so I thought, the only reason why this is taking place is because the federal government has got Section 230 and antitrust in its pocket, and it's, to mix my metaphors, and it's got these big clubs available to it. And so it's treating Facebook and these other platforms like they're subordinates.
All right, now this to me goes to the heart of everything. The argument that the government was making to defend the Biden administration, and that several of the justices seemed convinced by, was, look, when the FBI comes knocking on Facebook's door or on Google's door, or the CIA does, or the CDC does, or the Biden White House at the highest level does, and they say, we want this information that you're allowing to be censored. You should not be allowing this information. And then what Justice Alito was saying is they're not polite about it. They're demanding. If they don't get answers right away, they say, how dare you not answer us? We want to hear your answer. They demand meetings. They want regular channels of communication that allow them to constantly submit censorship requests or orders to these big tech companies. Because, as Justice Alito said, the government sees these big tech platforms as their subordinates. And the reason they see them as their subordinates is because, unlike with media outlets, which are protected by the First Amendment, which can publish things even if the government dislikes it, at least this is the old form of journalism. It always used to be that way. The New York Times would publish classified information, and there was nothing the government could do about it. Obviously, during the Snowden reporting that I did in 2013 for The Guardian, and in 2014 and 2015 for The Intercept and media outlets around the world, I was always in conversation with the government, and the government was saying, we don't want you to publish these documents. And if they provided a good reason why we shouldn't, namely if they could convince us that publishing a certain document would cause a lot of harm to innocent people without much value, we would decide, okay, we wouldn't publish that. But that happened very rarely. It did happen one or two times, but very rarely. In the vast majority of the cases, the government understood that the power about deciding whether or not to publish resided with us. And they were trying to convince us politely and through persuasion about what we couldn't publish, but we knew that they had no power to stop us or to punish us if we did. And so the relationship was obviously one of them coming to us, hat in hand, trying to convince us. And what Justice Alito was saying here correctly is that if you look at the way the US government speaks to Facebook and Google and other big tech platforms, it's not that kind of a relationship, because there are all sorts of things that the US government can do to punish big tech if they do not comply. We saw this happen with Parler. Remember, Parler was the free speech alternative to Twitter at the time and to Facebook. And right when President Trump was banished, even though he was the sitting president of the United States, by Twitter and Facebook, something that world leaders, including in France and Germany and throughout Europe, that hated Donald Trump said was extremely alarming, to watch big tech silence the sitting president of the United States, Parler said, we're going to create a platform where there's no censorship, where people can speak freely, just like Rumble is now doing as the free speech alternative to YouTube. And you had government officials, including powerful ones in the Congress, come and tell Google and Facebook, or rather Google and Apple, you better remove Parler from your stores. How can you allow a platform that allows hate speech and disinformation to continue to be downloaded through your stores? And Google and Apple obeyed those requests and took out Parler from their stores, and then Amazon removed it from their web services precisely because they knew that Congress had the power to punish those companies in all sorts of ways. And there have been so many times when Democrats were in control of the House, and now that they're in control of the Senate, where they've summoned big tech CEOs before them. And they've said to them explicitly, we've shown you this so many times, either you start censoring more in the way that we want, you start taking down more disinformation and more hate speech, or we will act against you. So the relationship is inherently coercive. If the FBI calls Facebook, or the White House at the highest level calls Google or Twitter and says, why are you allowing these posts here? Why are you allowing these people here? We want them silenced. The idea that this is just persuasive, that they're just trying to convince these platforms benevolently to remove it, but the power rests with these platforms, is a fifth grade understanding of how the United States government works, especially when it comes to big tech. There are all sorts of protections big tech needs, particularly Section 230, which immunizes them from liability. If a user of Facebook posts something that's defamatory or if somebody on Twitter posts something that is somehow illegal, Section 230 says these platforms can't be held responsible for what their users publish. If you were to remove Section 230, you would destroy the business model of these companies. And the Biden administration has often held that club, that sword, above their head. Here from Politico in September of 2022, White House renews calls to remove Section 230 liability shield. So they know they have all these weapons in their hands to threaten big tech with. They use it explicitly. Now, the main case that has governed this situation, and it's one that we've covered before, was a 1964 case called Bantam Books. And what happened in Bantam Books is perfectly applicable to what the Biden administration is doing here. And I actually was writing about this before this case even existed. Back in 2019 and 2020, I started saying the US government's efforts to influence what big tech can and cannot allow is crossing over into censorship of the kind that the US Supreme Court in Bantam Books said was unconstitutional, because what happened in Bantam Books was that a bookstore in Rhode Island was selling a book that had sexual themes, and a local zoning board in Rhode Island thought that that book was inappropriate, that it was obscene, that it should not be sold. Now, they knew they couldn't directly pass a law banning the selling of this book, because that would be censorship. That would violate the First Amendment. And so what they did instead was they started threatening the bookstore and the publishing company with all kinds of fines and all kinds of investigations and all kinds of violations. In other words, intimidating them to take down the book voluntarily. And ultimately, the bookstore took down the book, and the publishing company sued and said, yes, the US government didn't directly censor, but what they did was they intimidated the bookstore into doing for the government what the government was barred from doing directly, namely removing the book. That is exactly what the US government has repeatedly done when it comes to Facebook and Google and every other platform, is they're constantly using their threats, both in Congress and in the White House. So when you get a call from the highest level of the White House, and they're not just calling and saying, hey, we would appreciate it if you removed down this post. They call and say, we told you 2 days ago to remove this post. You better effing remove it. And they've used profanity and they use aggression. And they're speaking to them, as Justice Alito said, like subordinates. That is a case where the government has instituted a regime of censorship, precisely where the big tech companies know that they don't actually have the option to do it, because if they don't obey, they will be punished. Here is Mark Zuckerberg, the founder and CEO of Facebook, in June of 2023, making an extraordinary confession about exactly what was happening precisely at the time that all of this pressure was being applied. This was during COVID, when the government did not want anybody questioning the efficacy of masks, the efficacy of lockdowns, the efficacy of school closings, and ultimately the safety and the efficacy of vaccines. They were calling Facebook all the time and saying, we demand that you remove this content. This was also a time when the Biden administration did not want anybody questioning the integrity of the 2020 election. And so they would call people up, and they would call Facebook and Google all the time, and they would say, there are these people spreading doubts about the integrity of the 2020 election. Why are you allowing these political viewpoints to remain up? And here is Mark Zuckerberg explaining how Facebook perceived all of that pressure.
So misinformation, I think, has been a really tricky one, because there are things that are kind of obviously false, right, that are maybe factual, but may not be harmful. So it's like, all right, are you going to censor someone for just being wrong? It's, if there's no kind of harm implication of what they're doing, I think there's a bunch of real kind of issues and challenges there. But then I think that there are other places where it is, just take some of the stuff around COVID earlier on in the pandemic, where there were, real health implications, but there hadn't been time to fully vet a bunch of the scientific assumptions. And, unfortunately, I think a lot of the kind of establishment on that, kind of waffled on a bunch of facts and, asked for a bunch of things to be censored that in retrospect ended up being, more debatable or true. And that stuff is really tough, right? And really undermines trust in that. And
so what he's saying there is that you might have people saying factually false things online. Maybe they're saying 2 + 2 = 5. And he's saying, are you supposed to censor them just because they're wrong, even though there's no social harm to them saying that? Maybe they're saying the capital of the state of New York is not Albany, but New York City or Buffalo. Are they supposed to be censored just because they're wrong, because it's disinformation? But what he said was that the government and the medical establishment had declared certain views to be wrong that were not only debatable, as it turns out, but actually that were true, People questioning the efficacy of masks or the efficacy of or wisdom of school lockdowns or school closures or the safety and efficacy of vaccines. He was saying the government and the scientific establishment was telling Facebook at the time, you must take this down because it's false. And it turned out, he said, that those things were at least debatable. And some of the things they were demanding be taken down actually turned out to be proven true. Some of the things they were demanding censored. Now, within the investigations that have been done by Congress and within the limited discovery that plaintiffs in this lawsuit obtained, there are all these emails inside Facebook where officials at the highest levels are saying to one another, the government is breathing down our necks and demanding that we remove this content. We don't want to, but we feel like we have no choice. That's something that you can read documents at the highest levels of Facebook where they're saying these are not things we want to take down, but the government is demanding that we do so. And not only does the government have the ability to punish these big tech companies, they also have the ability to bestow on them huge benefits, massive contracts. So if you're the CEO of a publicly traded company like Facebook or Google, you actually have an obligation not to go to war with the US government. Precisely because the US government can harm you in so many ways. You have the duty to maximize the value for your shareholders. And so when the people call who can punish you and destroy your company by removing Section 230, or conduct criminal investigations against you like the FBI can, or who can lavish you with major contracts like the White House and the Pentagon can, when those people call at the highest levels, not junior functionaries, but political leaders at the highest levels call and say, we want these people silenced and we want these posts removed, of course that is not voluntary in any meaningful way. It is inherently coercive. It falls directly into what the Supreme Court in that Bantam Books case said was unconstitutional, namely that once the government starts intimidating private actors or threatening private actors or coercing private actors to engage in the kind of censorship that the government would be barred from engaging in directly themselves, then it becomes unconstitutional. Now, as I said, there were several Supreme Court justices that seemed not just comfortable with the idea that the Biden administration needs to be telling big tech what to take down, but who believe that it's urgent that they do so. And one of those justices was Ketanji Brown Jackson, who made some pro-censorship arguments that were so extreme that it actually kind of shocked me to hear a Supreme Court justice advocating a view of censorship that the Supreme Court has repeatedly rejected. But the reality is, as I said earlier, that it's almost a religious conviction now on the part of American liberals that things like disinformation are so dangerous and social media is so dangerous that, of course, we have to have the government exercising the power to dictate what can and cannot be said. When Matt Taibbi went to testify before the Congress, I remember very well that the House member from Texas, who's a Democrat, whose name is escaping me, he's actually the Democratic nominee to run against Ted Cruz in Texas. We'll get his name. He's a former football player. He now represents Texas in the House. But anyway, in a video I've shown many times, he said to Matt Taibbi, you should be grateful to the people in the CIA. Colin Allred, exactly. His name is Colin Allred. He said, you should be grateful to the CIA and the FBI and the White House for censoring. And if you remove your tinfoil hat, you would understand that these people are acting to protect us from dangerous things online. This is absolutely what is embedded in liberal discourse. That's why every Democrat virtually defends the U.S. security state censorship efforts. It's why the New York Times ran an article this weekend designed to depict free speech as an annoying and dangerous impediment to allowing the government to do what it needs to be doing, which is combating disinformation. And it's why people like Ketanji Brown Jackson, despite having gone to law school and despite being a member of the Supreme Court with decades of precedents that ban censorship, now aggressively defending the need of the government to be able to censor. Listen to what she said.
Well, whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you
hear that? There could be, she said, instances in which the government could prohibit political speech from appearing on the internet. She's not even saying here what some of the other justices seem prepared to say, which is that the Biden administration didn't force big tech to censor anything. They just kind of made nice suggestions, like, oh, we would appreciate it if you removed this post because this contains disinformation. Or this article about vaccines we believe is dangerous. We would like it if you would take that down. That wasn't her argument. Her argument was, even if the government is ordering big tech to censor information, this is something the government has the right to do. I'll just start at the beginning and play that again because it's extraordinary to listen to.
Well, whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest in how the government has tailored its regulation?
Certainly, Your Honor. I think.
Now, let me just say that sometimes the lawyers that you end up having defend the view that you hope wins don't do a great job at oral argument. And I don't know, Benjamin Aguinaga, he's the Louisiana Solicitor General. This case was originally brought by the states of Louisiana and Missouri by the Attorney Generals. That's why they're the plaintiffs in the case. And this is why the Louisiana Solicitor General ended up arguing the case for the plaintiffs against the Biden administration. He was not an effective advocate at all. He did not come prepared on the core question. Because, of course, there are times when it would be okay for the government to tell big tech, hey, this post contains some really dangerous things. We would appreciate if you would take it down. And the court kept asking, given that, of course, sometimes it's not completely prohibited that the government communicates with big tech, where's the line that you draw between when it is permissible and when it becomes coercive censorship? He was ill-prepared to answer that question, and it really frustrated the justices because I think they were looking for some standard, some line to draw to decide if the Biden administration fell on the wrong side of it. And this question, too, he did not handle well. She was saying that there have to be some instances where the government can, in advance, censor. And instead of saying, no, that's prior restraint, the Supreme Court has often ruled that the government has no power of prior restraint. It cannot censor political speech in advance that way. He agreed with it and kind of mumbled and allowed her to take a very extremist view of censorship and the government's power to do it and to get away with far more than she should have been able to.
Prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest in how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate.
All right, so not every situation in which the government engages in conduct that ultimately has some effect on on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again, because if you control
That's not the test for First Amendment violations.
Your Honor, this flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
It can, Your Honor, and I guess what I would say is that the courts below never got to strict scrutiny because the government never raised this. This has never been litigated. The question in this case is whether at the front end the government itself has undertaken
action. Is the coercion, is the state action, right? That's the question in this case.
And I would urge the court to address the state action issue just like you addressed it in Bantam Books. Use that term 4 times in Bantam Books.
And could I just understand, because it seems like an extremely expansive argument, I must
say.
So
I say that I don't think that's going to be the basis on which the Supreme Court rules in favor of the Biden administration, if it does, namely that, well, sure, the Biden administration censored and they have every right to. But the fact that there was at least one justice on the Supreme Court who now is of the view that the government has the right in advance to censor political speech, what she's referring to is the idea that on some level, every constitutional right can be limited if a very high standard is met. But it's not a prior restraint on free speech. That is never permitted. That was what the Nixon administration tried to do in the case of the Pentagon Papers. When Daniel Ellsberg gave the Pentagon Papers to the New York Times, the Nixon administration tried to stop it in advance from being published, and it went to the Supreme Court, the most important press freedom case in history. And the Supreme Court said, it may be that the government can prosecute the New York Times after the fact for publishing this information if the government can meet all these extremely high standards for being able to prosecute a newspaper, but they can't do it in advance under any circumstances. That would be prior restraint. And what Ketanji Brown Jackson was saying was that, of course, sometimes the government does have the power in advance to say this information on social media is so bad and so wrong and so dangerous that, yes, we have to allow the government to be able to order big tech to remove it. She's defending that position. Here is another exchange where a similar issue emerges, though even in a more extremist and clear way.
Concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. I
want to play that again because this is at the heart of it. And this is what the New York Times article from this weekend that I want to review in just a second also tries to implant. She believes, and I think other colleagues of hers on the Supreme Court also are ready to say, that the Supreme Court is like an impediment, or I'm sorry, the free speech guarantee is like an impediment to the government being able to do things it needs to do, that we need it to do. She's saying the First Amendment hamstrings the government from doing things at the most important moments that we need it to do. For example, if there's a COVID pandemic, we cannot allow dissent to the decrees of the scientific establishment about what people should and shouldn't do. It's too dangerous. And we can't allow the free speech right of the Constitution to hamstring the U.S. government from doing the important things it needs to do to protect us. This is exactly what the New York Times did. It depicted free speech concerns as an unreasonable and far-right obstacle to having the government do what it needs to do in this dangerous time, which is protect us from disinformation. This has become the religion of the liberal establishment about why censorship is so necessary, and it became so manifest. I mean, to hear it being advocated by journalists is one thing. To hear it being advocated by a Supreme Court justice is something else entirely.
My biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. I mean, what would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country, and you seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information.
I mean, I can't let this go in terms of how extremist this is. She created a hypothetical, and several of them did as well. Let's imagine that something really bad is going on online. There's some claim being made that's dangerous or false. And the justices are saying, doesn't the government have to be able to call big tech and say, take this down? And the response of the Louisiana Solicitor General, which in this case was quite good, was no, the government has a lot of options. Joe Biden can go on national television at any moment that he wants. The U.S. government has all kinds of powerful megaphones to counter speech that it claims is false. That's the constitutional framework. The way the government is supposed to respond to speech it regards as false and dangerous is not by calling people up and ordering it to be taken down. That's what the First Amendment is there to prohibit. The solution, if there's dangerous things being said that might be harmful to children or adults in a pandemic, is for the government to go and try and convince Americans that that information is false. And that's what he was saying. The government has solutions. They're not required to sit by silently. Members of the executive branch, members of Congress are permitted, and they do all the time, say, there's things going on online being said that we don't agree with. And then the citizens get to hear from their government. Their citizens get to hear from their opponents and from dissidents of the government. And one of the things social media has liberated us from is the fact that we no longer are imprisoned in the power of a small handful of gigantic corporations, all of whom have the same identical interest in serving the government's messaging. This is what they're afraid of. This is what they're saying. I appreciate Justice Brown Jackson for being as explicit as she is. She's speaking for American liberals here, and she's saying we can't allow free speech anymore. It's too dangerous. That's what's at the heart of this case. That's what is at the heart of the Biden administration's behavior. It's what the heart of all these laws that countries throughout the democratic world are enacting to control the internet, that they believe free speech no longer is a luxury that we can afford. Because not really just hate speech, most importantly, disinformation is something that is too dangerous to permit. And I guess at the end of the day, there probably are two groups of people. One group is a group that believes that the government can be trusted to dictate what is and is not disinformation. And remember, if you think I'm exaggerating, that Homeland Security tried to create an office led by that crazy woman, Nina Yankovic, that was designed to do exactly that. And that became a bridge too far, thankfully, even for our political culture. But the New York Times article this weekend, which I'm about to show you, actually held that up as an example. The failure of the Homeland Security Office as a way in which right-wing fanatics are using free speech to prevent the government from helping us and protecting us. The failure of that Homeland Security Office. So that's one group of people, people who trust the U.S. government to dictate what is and is not disinformation and to censor the internet based on their judgments. And the other group is people who do not trust the government to do that. And I would suggest that the only way to believe in the Constitution is by being in this second group. Thanks for watching this clip from System Update, our live show that airs every Monday through Friday at 7 p.m. Eastern exclusively on Rumble. You can catch the full nightly shows live or view the backlog of episodes for free on our Rumble page. You can also find full episodes the morning after they air across all major podcasting platforms, including Spotify and Apple. All the information you need is linked below. We hope to see you there.